Okay, good morning and welcome to the August 2019 meeting of the New York City Campaign Finance Board. First item on our agenda is the approval of the minutes from the July 18 meeting. I was not present, so I've
So moved.
asked somebody else to move. Okay, is there a second? All those in favor?
Aye.
Opposed? And I abstain. So the motion carries. Next is the report of the chair. So here it is. The 2021 elections will usher in a new wave of leadership in city government. With the mayor's office, controller, all 5 borough presidencies, and 2/3 of the city council districts expected to be open seat races due to term limits, we also anticipate a record number of candidates. The 2021 elections present any New Yorker who has ever thought about running for office with a wonderful opportunity to do so. Recent changes to the matching funds program mean that the city candidates will never have to rely on big money from special interests to run for office. Under the new 8-to-1 matching rate, New Yorkers can run a strong campaign that's based entirely on small contributions from friends and neighbors living in the communities they hope to represent in government. The CFB has been touring the 5 boroughs this summer to help New Yorkers seize this opportunity. Our 5-borough tour continues through the middle of September with a final training session in Harlem on the 14th. At these sessions, designed for anyone who is new to the CFB, agency staff introduce the matching funds program and provide an overview of what it takes to start a campaign. CFB staff presented to a dozen people in Staten Island this month. To date, they have helped more than 100 potential candidates learn about the nuts and bolts of the matching funds program at sessions in Brooklyn, Queens, the Bronx, and Staten Island. Follow-up seminars focused on complying with the law begin in Queens this Saturday, August 17th. We look forward to meeting new and prospective candidates throughout the city as we gear up for the 2021 elections. Please visit our website at nyccfb.info and click on 5-borough tour at the top of the page for sign-up information. That's my report. I'll now turn to our Voter Assistance Advisory Committee Chair, Naomi Zouderer, for her report.
Thank you, Chair Schaefer. The Voter Assistance Advisory Committee is coming off an exciting week as the NYC Votes street team hosted our first ever public hearing held by, for, and about our city's young people. Last Wednesday, we heard from dozens of young New Yorkers who spoke from the heart about how NYC Votes could bring more young people into the political process and increase youth voter turnout. The presentations were exciting, inspiring, and full of great ideas. All of the testimonies and a report from our street team will be provided to the New York City Council and the City Board of Elections for their consideration. Luckily, we have an opportunity to put some of those ideas into practice right away with the 2019 general election coming in November. All city voters will make a decision on public advocate and on ballot initiatives proposed through the Charter Revision Commission process. In addition, voters in Queens and in Brooklyn's Council District 45 will pick their next district attorney and city council member, respectively. As with each city election, we will release a nonpartisan voter guide in print and online in the weeks before the election day to help New Yorkers learn about each of the candidates and ballot initiatives. Most importantly, this will be the first time in New York City history that poll sites will be open for early voting starting 10 days in advance of Election Day. New Yorkers will now have the much needed and long overdue flexibility to vote at a time of their choosing, including over 2 weekends, rather than on a single day. NYC Votes will release a short animated video to let New Yorkers know about the convenience of early voting in the coming weeks. And with that, I'll turn it over to our Executive Director, Amy Loprest.
I just want to, again, commend our street team that did an incredibly great job of organizing that hearing. Really an energizing and wonderful presentation from young people all over the city. It's very inspiring to know that the younger generation is really concerned about civic engagement and are looking to get more involved. So we will be pursuing ways to make that happen, both in NYC Votes and across the city. The staff is busy preparing to implement all of the recent changes through the Charter Revision Commission from last year and the legislation that was passed by the City Council earlier this summer. We are gearing up for the 2021 election. There's only 16 months before the first payment for that election, so the staff is busy implementing both computer and education systems to help the candidates navigate the new law.
Thank you. The next item on our agenda is our periodic announcement of campaigns that have been found to be in compliance. The following candidates from the 2017 elections have completed the post-election. I'll start again. The following candidates from the 2017 elections have completed the post-election audit process without any violations or penalties assessed by the Campaign Finance Board. The board recognizes the diligence of the candidates and their campaign staff in running campaigns that maintained compliance with New York City's campaign finance law. Of these 15 campaigns, 10 were first-time candidates with the CFB. So it is possible, despite the complexities of the law, to comply your very first time out. So here are the candidates and the offices who were found to be in compliance. Jennifer Berkeley, who ran for City Council District number 40. Joseph Borelli ran for City Council District 51. Gail Brewer ran for Borough President of Manhattan. John Serini, City Council District 13. Raimondo Denaro, City Council District 47. Amanda Farias, City Council District 18. Diane Mack, City Council District 9, James Odo, Borough President of Staten Island, Juan Carlos Polanco, Public Advocate, Keith Powers, City Council District 4, John Quaglione, City Council District 43, Justin Sanchez, City Council District 14, Stephen Saperstein, City Council District 48, Michael Tolkien, Mayor, and Paul Vallone, City Council District 19. We have appearance today by two candidates who are contesting proposed penalties or repayment obligations. We'll take them in order. The first is Pierre Gooding. Mr. Gooding, are you here? Good. Why don't you have a seat up here, and staff of the CFB will take a seat at the other table. So, Mr. Gooding, let me just give you a brief summary of how this works. The staff will present a very short summary of what the issues are, really just not an argument so much as just an outline of why we're here. I'll then turn the floor over to you, and when I do, you'll push the button there and turn that green so that your mic is working. You can take some time to set forth your arguments. When you're done, I'll give the CFB staff an opportunity to respond. There may be questions from us. And then when we're done, we'll go into deliberations. And after deliberations, we'll come back out and announce a decision. Okay? So why don't you guys start?
Good morning, Chair Schaefer, Executive Director Loprest, and members of the board. My name is Cameron Ferrante. I'm a Senior Associate Counsel for the CFB, and with me today is Anthony Grion, a CFB Auditor. Before the board is the matter of the Pierre Gooding campaign in the 2017 elections for City Council District 9. The candidate was a participant in the program but did not receive public funds. CFB staff recommends that the board find that the campaign committed the following violations of the Act and board rules and assess penalties according to the 2017 penalty guidelines. Violation 1, from a corporation. 2, filing late disclosure statements. 3, failing to provide bank statements. 4, converting campaign funds to a personal use. And 5, commingling campaign funds with a personal or business funds or funds accepted for a different election. The campaign contests these violations and recommended penalties.
Very much. Mr. Gooding, the floor is yours.
Thank you to the Campaign Finance Board and to the board members for this opportunity to speak. As you know, my name is Pierre Gooding. I'm here today because I believe, although I know the Campaign Finance Board has a job to do, that some of the penalties presented represent a gross misrepresentation of what has occurred over the past 2 years, or what happened for 2 years during our campaign. And so I want to set the record straight. I understand that fines need to be levied in some areas, but also I want to make sure that what actually occurred during the campaign is noted, because we were at the Campaign Finance Board consistently to ensure that the processes that we were putting in place were correct. Now, on the back end, to see that they weren't, or supposedly we're trying to get to the bottom of this, because we wanted the entire time to have no violations. So to see this, ultimately, I just want to make sure that we know what to do even moving forward for the next campaign. So this is not an antagonistic process. We just think that some of the issues, particularly the charge of converting campaign funds to a personal use, is a gross misrepresentation of what happened. We asked our advisor if what we were doing was practical and within the rules. We were told yes. We were told that multiple.
What did you ask, and what did you tell them?
Thank you. First time out, there was a meeting with Zoe Coyle here in one of these rooms, where I specifically asked if we could purchase food on a one-on-one basis while we were meeting with constituents, because it was a necessary question, considering that was what we were going to do to campaign. We needed to know the answer up front. We were told it was okay, so we moved forward. Sure. I was in a room somewhere here with Zoe Coyle, and during that time, I asked specifically if the campaign could use our funds to purchase food for individuals while we were meeting with them. That was the question we need to know.
So the one-on-one is you're meeting with a single constituent from whom you're trying to raise money, and you're purchasing food for that person.
Or trying to garner his or her vote. So explaining what the campaign is doing. And we were running around, this is for over 2 years. We were running around meeting with individuals on a one-on-one basis. And I understand that if, from an external perspective, when you look at it, you say, well, what was going on day 120? But some of the charges, yes, were under $5 because the person wanted a Snickers bar. And the campaign thought that that was okay. And so we provided what the individual asked for. Now, if we had known at any point that that was improper, we would have stopped doing it. And that's why we asked the question repeatedly, because I did not want this to happen. And further, we never converted a dime of funds that were given to us. Every single penny we put into the system to show what we were doing. There was no nefarious activity going on. And so we just want that on record. There are some other aspects of this, such as did we file bank statements after November? The bank account is closed, which I have. And in the campaign.
Could you stay with the conversion issue for a little
absolutely.
bit longer?
Yeah, of course.
Let's sort of finish up on that one.
Absolutely. So
you've talked about food. There are also travel expenditures. There are also some expenditures from clothing or department stores. Why don't you address some of those other expenditures?
I appreciate the opportunity. Philadelphia, where I have gone to school to try to garner donations from interested parties, individuals that would likely donate to the campaign. Now, we spoke with individuals and did garner a donation, but of course it didn't yield what we wanted it to, but we had to try. the analysis of whether you could travel to another city to fundraise, I thought was well within our rights. And so I just on the back end to see this sort of shown as something that was outside of a campaign, I don't understand what.
So let me ask you the more specific question. I think the question arose because ordinarily when you go to do a fundraiser someplace, you sort of collect contributions that day, or maybe they trickle in the next day. In the case of Philadelphia, the one contribution that you got that was after your trip there came a little more than 2 weeks later. Do you have any understanding of why there was that gap?
It actually required follow-up. I mean, there were individuals that we met with, and then we followed up with those individuals. There were a lot of pledges, and one thing that we found out during this process, that is harder than it seems to fundraise. It is harder than it seems to run for office. And so things that appear easy, fundraising, garnering donations, they're not. And so that one donation was the outcome of hard work put in to get the donation. And we, of course, spoke to more people, but there were a lot of pledges and not as much action as we would have liked on those pledges.
What about travel expenses other than the trip to Philadelphia?
Other than the trip to Philadelphia, if there are expenses outside of New York City, they were campaign related. We were doing things outside of New York City that required us to use what we didn't want to do is not use the account and then be fined for doing campaign activities with a non-campaign account. So this is exactly what we were trying to avoid. And now I'm looking at violations that make it seem as if we were not here consistently trying to follow the rules. And that's why I'm concerned. 125% penalty for converting campaign funds is clearly a penalty for intent. And there was none here. It was the exact opposite.
This question, Mr. Gooding. In July 26, or it's dated July 26, you got a notice that there'd been a compliance visit, and it said you didn't provide sufficient documentation demonstrating the appropriateness of the expenditures listed in Exhibit 1. And if you look at Exhibit 1, it's the kind of expenditures that form a lot of the issues that are before the board right now in terms that continued. What steps did you take, if any, to get documentation to show that this wasn't just you or somebody saying I'd like a cup of coffee or I'd like an egg roll from the Szechuan place, as opposed to something that was more campaign related as opposed to personal related?
Glad that you brought up Szechuan Garden. That was a specific question that was asked it was a conversation between me and Sonia Munoz, where she pointed at that expense and said, I have seen other campaigns that do a similar thing, that buy food for the campaign. And so we continued. That's what I'm saying. I'm not saying that it was.
No, but you got a letter that said that you didn't have sufficient documentation to demonstrate those expenditures were appropriate.
Well, we had bank statements for everything. At the time, you're right. At the time, we weren't filing bank statements, even though we had them.
These aren't bank statements. These are documentation to show that food expenditures are somehow linked to the campaign. We're essentially taking this on faith that we don't know you, you don't know us, but an expenditures at Wendy's for $12.99, and expenditures at KS Deli, etc., and at all these Atomic Wings and on are not personal expenditures as opposed to campaign expenditures. There's no document which demonstrates that is a campaign expenditure.
Board Member Davis, I agree, and I believe there's a charge for failure to demonstrate that a expenditure is campaign related. I understand at this juncture, it will be hard to show what we were doing. But I do feel that if anything is going to happen, a failure to prove that funds related to the campaign is at most where we're at. It's just saying that we've converted funds is just considering the amount of times, and you can see from the records the amount of times that we were here asking these questions. And if you ask Zoe Coyle, she should tell you the answer to the question, which is that we had discussions about these types of charges.
But you're not really addressing, you were told in July that for these kind of expenditures, you didn't have adequate documentation. And yet these kind of expenditures continued up through September, October.
When we had this meeting,
So the question is through November, and I'm not hearing that you took any steps to show that these kind of expenditures were campaign related.
no, I did not, because at the time we were told, you're not filing bank statements, file the bank statements. As we started filing the bank statements had every single expenditure we had. So
you were told that the reason your documentation was inadequate was because you hadn't filed the bank statement?
that's what, there should be an email to that effect. And that's why I had all the bank statements ready. Now I have a box of receipts that say the same thing that the bank statements say, but no, I don't have a document saying that I met with Lewan Robinson on July 22nd.
So let me bounce this back to CFB then. What is our rule or policy or practice with respect to what would constitute an adequate documentation that $5.99 charge at Starbucks was campaign related?
Well, first and foremost, we need to see some sort of receipt to demonstrate.
Could you speak
that,
up a little?
Oh, sorry.
Some receipt.
Some type of receipt, and also some explanation as to the event that was occurring. I mean, if it's like a one-on-one meeting with a potential contributor or supporter, or someone who's going to give their endorsement, a communication with that person, or some evidence that the meeting actually occurred.
So if you saw the receipt from Starbucks and the candidate wrote on the receipt, I met with Mr. X, a potential voter or contributor, that would be sufficient.
Yes.
Okay.
Yes, that would be.
Now back to you. So you say, in addition to the bank statements, you have the receipts which reflect the same amount.
Absolutely.
But presumably you did not make a note at the time of who you met with. Do you have a campaign diary or some document showing day by day who you met with?
I could put together a list of individuals that we met with. It wouldn't coincide with the day, but we could do affidavits that show that we met with the individuals. Because we can put it together. I was not under the assumption that would matter, but if it was determined, if we could get it.
Meeting with the campaign with the CFB staff, your understanding was that the lack of documentation had to do with bank statements and not receipts or names of people you were meeting with?
In that regard, I just want to look at the letter that we got, which explicitly says what the expenditure documentation would be. And I just want to note, it talks about invoices, appraisals, contracts, receipts, and proof of payment, such as copy of the canceled check. Obviously, all of these wouldn't apply as to all of these, but it really doesn't mention bank statements. I think the bank statements are a separate requirement.
Such as a copy of the canceled check and the associated bank statement.
Right, but you need the canceled check.
Mm-hmm. Right.
It's not
Right,
just that
right.
Not just saying give us a
Right.
bank statement that shows
Right.
money out. Like for example, I'm not sure how are these paid for?
Just like that's yes, sir. We had
Cash?
exactly. We wanted to avoid that, so every charge we put on the card so that we could show the CFB what we were doing. Yes, that was the point.
Interject. There are numerous instances in which the campaign actually their bank statements reflect cash withdrawals that were later reported as some type of expenditure. However, since we have no receipts or other documentation other than the bank statements, like you were
Do you ever
mentioning.
get the receipts that you're now talking about?
No, we received virtually no expenditure documentation other than the bank statements from the campaign, which they didn't provide until after the draft audit report was issued. And so I think we didn't get more than about 3 bank statements until June 2018.
Generally speaking, about how many such meetings did you have? Sorry.
Yes. I had at least 2 meetings here with Zoe.
No.
I'm sorry.
With your contributors.
Oh,
or potential-
okay. So I quit my job. This was a real campaign that was done on a daily basis. And that's what you see in the spending. You see daily transactions because that's
Generally speaking, about how many such meetings?
I would say we met with at least 1 to 2 individuals per day. We tried to make it more, but I'm talking about actual 20-minute to 30-minute meetings where we're sitting down with folks.
Is it 40? Is it 100?
No, I'm saying we met with at least 1 to 2 people per day.
I know, but I don't know how many
How many
days.
days? How long did the campaign last?
How long? Oh, the campaign, started in earnest before the special election, January 2017 was, February 2017 was the special. So January 2017.
It's somewhat complicated by the intervening special election, but the campaign originally registered with us in December 2016, and then the primary election was in September 2017.
So we're
But
talking a 6, 7 month, 8-month period.
Yes.
thereabouts, yeah.
So you ran in the primary, but not in the general?
The plan was to run in the special election. There was,
But putting aside the special, because I think you terminated that candidacy.
correct.
And you ran in the primary.
So during the primary, there was a contest by Marvin Holland over ballots, over signatures. Even though I turned in over the requisite amount, I was knocked off the ballot through that process. At that point, we obviously were going to continue because we were participating in the general election no matter what. But that was what happened with the Democratic primary.
The general election.
I'm sorry?
You ran in the
I
general
did, under the Reform Party banner.
I'm still having trouble understanding something. Let's focus now on the audit process rather than your initial meeting of. So you get notice that the CFB finds this insufficient documentation that these expenditures were campaign related. You say you probably have many or at least some receipts from these various food establishments. Why weren't those proffered during the audit process?
I appreciate the question. The first instance of a letter that I got was saying, we don't have bank statements, so we're going to fine you. We don't know what went on with your campaign. We immediately said, okay, that's a problem, and sent in every single bank statement that we could come up with and proffer. From that, we got the letter with the violations. At that point, the violations weren't about whether the charge happened. They said that based on the percentage of times that we made food a part of our campaign, that was enough to charge us 125% of all of those expenditures. And so at that point, the argument was whether this was correct or not. We went from a lack of bank statements. I turned in the bank statements, and then we started arguing over these specific violations. So after the bank statements, I thought we were pretty much in the clear. Whatever was going to happen was going to happen, but we were not going to see this. When I got this back, that's when the alarm bells went off, because after we turned in the bank statements, we see all this.
Let me ask another question. In terms of all the food, I guess that added up to, in round numbers, about $3,500. But according to the staff, that even if you gave you credit for all the food and travel, there's another $5,700, again, in round numbers, that there's no documentation for. And I assume that includes the Models, Marshalls, and things like that. What is the documentation for the non-food, non-travel items.
Yeah, in terms of documentation, again, this is just a matter of what we thought needed to be done and why we were working with the CFB the entire time. During the course of the campaign, we were trying to turn in every document. When we were told that bank statements were missing, we turned those in. In retrospect, I wish that I had written on either the bank statements or receipts or whatever exactly what we're doing. Of course, we would have avoided all of this. It's something for me to know, but we were trying to do things the right way, and I don't think that's being accounted for.
Yes, this is getting into the weeds, I realize, but if I'm a candidate and I take a constituent or potential constituent out to Starbucks, and I have the receipt from Starbucks, and I submit that receipt to the CFB as documentation without any notation as to the name of the person who I bought the coffee for. And then you come back and say, well, it'd be better if you had the name of the person. And I say, I'm sorry, I don't remember, but I saved the receipt. Would that have been sufficient? Or, I mean, what would the audit reaction to that be?
Well, that's in like a normal context. So normally those types of expenditures on food or refreshments or things like that are presumed to be in furtherance of the campaign. So if a campaign came in and said, I've got this one expenditure at Starbucks, here's the receipt, I can't remember who I met with, that would probably be sufficient for our
Suppose there were
purposes.
100.
Suppose what?
There were 100 of them.
Exactly. So once they've spent an unusual amount of money or a disproportionate amount of money on those types of expenditures, we demand more accurate documentation or more than just simply the receipts.
And what makes that unusual or disproportionate? Or is this not a common thing to spend money taking out people to Starbucks?
In my experience, this is not a common thing.
Right.
You can speak more to the audit's process.
Yeah, I mean, based on other campaigns, their activity, this was, not in the normal range of food expenditures, I would say.
Yes, certainly campaigns spend money on food.
Right.
Yeah.
It's the, one-on-one looking like you're, and the large percentage that is the extraordinary.
So the problem we're having, and I want you to understand and appreciate this too, is that when it's one-on-one, it obviously could be exactly what you say it is, but it also looks a lot like a candidate's taking himself out to lunch. And that's the problem we're faced with here.
Board Chair Schaefer, I understand the quandary that the board is presented with, which is why in this particular situation, of course, I don't want to be fined, but I feel if anything is going to happen, that a failure to show that this was in furtherance of a campaign is the proper charge, which would ensure that I don't get fined at 125%, considering the fact that I was attempting to do this the right way, and the documents should show that. 125% fine is clearly punitive, and it's clearly based on an intent to deceive and defraud, and it's not what happened in this campaign. I don't think it's appropriate.
Okay, why don't we move on to some of the other issues?
Yes. Okay, so the bank statement, there's a failure to provide bank statements. The bank account has been closed since November. CFB is well aware of that. I have made them aware of that. I went to TD Bank. I asked them for documents to prove that whatever the campaign finance board wanted had happened. They laughed in my face. They said, the CFB is asking for too much. We don't do that. The account is closed. And that's the end of it. There's nothing more I can do to show that the account is closed because TD Bank won't give me a statement. It's closed. That's a fact. So I'm not sure what we're actually talking about.
Well, we have no proof of account closure. Normally, a bank would issue a statement confirming that the account has been closed, or we would have received a statement in November 2017, which was truncated or otherwise indicated that the account had been finally closed. All we have at this point is a statement from November 2017 showing a zero bank balance. And given the general unreliability of the campaign's reporting, and there's actually I believe an expenditure from November 30th, which isn't even included that's reported, but not included in the November 2017 bank statement. So we believe that it's not unreasonable to assume that the campaign either may have continued to raise or spend funds after November 2017.
But it was zero in November.
it may have been zero, but there's expenditures that are reported that aren't reflected on that after the last date on the November 2017 statement. So, and I'd also just like to say that the $50 penalty is actually a reduction from the standard $100 penalty already, which reflects the limited amount of funds that are available in the account or assumed to be available in the account.
Okay, you want to address some of the other issues?
Crowd pack. Initially, as legal counsel Cameron has noted, it was a bit of a special situation. When we started the campaign, I do not believe NYC Votes or NYC Contributes was functional. There was a problem because we were now candidates for a campaign. People were really excited. So as a first-time candidate, in your first 2 weeks, people are incredibly excited. They want to donate. There was no mechanism for individuals, particularly young individuals, who are going to use online systems as opposed to cards or compliance cards or whatever the cards were. They use online systems. They wanted to donate, and there was no mechanism.
What are you addressing now?
When I went in December of 2016, when I registered to become. There was no system, so we used CrowdPack. It was a disaster because we then had to move all that over when NYC Contributes became functional. Again, we were trying at every step to do this the right way, considering what was going on. We didn't want to use CrowdPack. We wouldn't have used it if there was a system in place for us to receive donations. Once that system came online, we shut down our CrowdPack operations and moved over to NYC Contributes per request.
So the campaign had actually registered already for NYC Votes Contribute as of 5 days after it registered for the 2017 election. And that was, I believe, almost a week before it received its first CrowdPack contribution. So it should have been able to receive NYC Votes Contributes contributions for the entire duration of its use of CrowdPack. It actually received its first CrowdPack donation on January 3rd and received its first NYC Votes Contribute contribution on January 5th. So they were operating in conjunction, and CrowdPack was essentially redundant at that point. On January 19th, the campaign was informed that the CrowdPack documentation was insufficient and were directed to solicit contributions through NYC Votes Contribute. However, they didn't cease, apparently, receiving contributions through CrowdPack until late April 2017. So there's about a 3-month span there where they knew that the documentation was insufficient and they'd been asked to direct voters to, or contributors to NYC Votes Contribute, and apparently failed to do so.
Can we talk about the Lee?
Yes, please.
This is an issue of first impression for us, I'm sure for you too. So let's talk about that.
I was approached by Leadership for Educational Equity as one of the organizations that were interested in me running for office. I worked with Leadership for Educational Equity through the Campaign Finance Board to ensure, again, that everything was compliant in terms of what we were doing. I was told that there was a meeting between Lee Legal and CFB Legal where whatever structure they had come up with was approved.
Who told you that?
Leadership for Educational Equity. Admittedly, not the Campaign Finance Board. What I did on my own at that point was go on the CFB website to see what the list of approved entities were to get donations from, because I was not going to get a donation from anybody that wasn't approved. Leadership for Educational Equity was listed as an approved source, and so we got a donation of $1,000, which was under the cap, and we thought that was the end of it. And now we're here.
They contacted you originally? What was it? Do you know how they came to contact you?
They were specifically looking for teachers to run for office, and so my name came up through that sort of catch-all. I don't believe there was anything that we could have done to avoid this penalty. At no point during the election were we told that there was anything wrong with the Leadership for Educational Equity arrangement. And we got the first that we were told about it was this letter. At that point, we flipped out because there's nothing that I could have done to avoid this fine. On top of it, I believe there's a process where you go from the first, what you tell the individual what happened, and if they don't return the campaign, they don't return the funds, there's an additional penalty or there's an escalation. There's no escalation here. We went from 0 to 100. I had no idea why. And now we have a $1,500 penalty slapped onto our campaign, and there's nothing I could have done to avoid it.
My question over here is, when I looked at the various email exchanges or email exchange and the contact record with LEE, it seems clear that they did not ask for specific approval of what they were doing, but it does seem that the CFB staff was aware that this was a situation in which the same group or related group was providing services, charging for them, and making a contribution. So I am concerned, again, I don't really question the conclusion that it's really, given how they're structured, it's one entity. However, I am concerned that wouldn't their ability to avoid this, if based on the information that CFB staff had, to ask a few more questions, even though that wasn't the purpose of the LEE contacts.
So I don't necessarily believe that CFB staff was quite aware of how intertwined the two organizations were at the time. I think they realized that there was essentially one person representing
same name.
Both.
I mean,
oh yeah,
it's same name. It's, it sounds the kind of thing.
I mean,
again, they didn't ask the right question,
mm-hmm.
and they should have. They should have come, because I think, and as I look, that they really should have asked the right question, and they should have come. But now we're looking at the issue of the candidate, and I'm just wondering, wasn't there enough information available to raise at least a red flag for somebody to ask a question?
I think at that point, specifically at the time that the John Dillon email exchange occurred, there hadn't been quite the same showing of, I'm using in a non-legal sense, coordination between the two groups. In this case, there was an agreement signed on March 15th to pay $1,000. And at the same time, on March 15th, they received $1,000 from the other organization. I don't think that fact pattern necessarily existed at the time. And that's really what raised the red flags.
I understand the precise fact pattern wasn't there. And I understand that they didn't get the kind of guidance, ask for the kind of guidance. So I'm not really being critical in the fact that we didn't. But it does seem that there was information floating around that one could have said, asked a few more questions, and maybe this issue could have been surfaced earlier.
That's very possible. It's in the middle of the election cycle, though, so I can see why the candidate guidance unit may have been otherwise disposed or distracted. But yeah, in terms of whether they could have rectified the issue at the time, it's possible in this instance, I think, given the nature of the transaction that occurred, where the campaign seemed to be aware that these entities were operating essentially as one and was accepting a contribution while at the same time paying out money, which was essentially the same contribution. It should have at least been aware that it was in effect receiving benefits of services without incurring any debt or at no cost to itself. So there should have been at least a report of an in-kind contribution of some sort rather than actual transactions in terms of a contribution and expenditure.
If there are no further questions, I'll give either side the opportunity to sum up.
I mean, should I go? I don't know who you'd like to go first here.
I think
Is there anything you
we'll.
wanna add?
I just want to thank the board for the opportunity. I want to thank the campaign finance board for the job that you do. I know that this is a difficult process. I know there's a lot of work to be done, but I do want to make sure that candidates who are trying to do things the right way are not put in a position where they are hindered or feel it's a disservice to run for office. I truly think there is a difference between individuals who are trying to do things the right way and those that aren't, and I think that has to be reflected. But again, I appreciate the board and the Board of Elections, which is not here, but the Campaign Finance Board's efforts, and I appreciate the board members' time. Thank you.
I'd just like to sum up by saying that responding generally to the campaign statements about it providing documentation and having various conversations with board staff that approved of its activities. There's no record that we have that suggests that those conversations occurred or that board staff at any point approved these various activities. The campaign also provided virtually no documentation and had numerous opportunities, or documentation of its expenditures, and had numerous opportunities to do so in response to the compliance visit letter in July 2017 and in response to the draft audit report, and then again in response to the penalty notice. We've received essentially no documentation other than, I believe, a small email exchange and half of a conversation contained in a text message. So
Let me ask you this. Mr. Gooding has suggested that the characterization of these expenditures as for personal use and the addition of the 25% kind of penalty on top of the 100% goes to the question of his personal integrity, and that the violation could as easily be described as a failure of documentation rather than as a conversion of campaign funds to personal use. Would you agree that that is an alternative approach that's within the law and regulations here?
I wouldn't disagree that it's an alternative approach. I think given the amount of funds, almost 80% of all campaign expenditures that were used in this way, and for which we have no supporting documentation to bolster the candidate's word, and given the general nature of the expenditures, I don't think it's unreasonable to attribute at least some sort of intent.
Okay, fair. I got your point. All right. Anything further?
No, I appreciate the board's time.
Thank you very much. Okay, we've got one more candidate before we go into deliberations. Mark Traeger. So, Mr. Traeger, you have the benefit of having watched the prior
He's not
proceeding.
Mr. Traeger.
Sorry. You are.
I'm Terry Cooperman.
Oh, okay. Got it. All right. So you had the advantage of watching the prior, plus you're not just a candidate, you're a lawyer on top of it. So I don't need to explain. So why don't we ask the CFB to tee up the issue for you? And this, I think, is going to be hopefully a shorter and more focused conversation, since we're dealing with really only one issue. Go ahead.
Good morning, Chair Schaefer, Executive Director Loprest, members of the board, Mr. Cooperman. My name is Bethany Persky, Deputy General Counsel for the CFB, and with me is Auditor Julius Diaz. Before the board is the matter of the Mark Traeger campaign in the 2017 elections for City Council District 47. Mr. Traeger was a participant in the program and received $99,850 in public funds. CFB staff is recommending that the board require the campaign to repay its final bank balance. The campaign contests the public funds calculation.
Okay.
Good morning, members of the board. Terry Cooperman, is this on?
You just
No,
press the
press the
button
button.
and I'll be green.
Now it's green. Okay.
Okay,
Go ahead.
so I was thanking the board. I'd also like to thank CFB staff, who was very accommodating and helpful throughout the process and professional. So the committee submitted its response to the CFB's enforcement notice on July 5th, and that was done in a timely way. And as I think the board understands, the CFB staff did not recommend that the board assess penalties or violations, but it did find that certain additional monies are required to be repaid by the committee. And I think the very short explanation for this is the committee mistakenly did not include in its submission in response to the enforcement notice certain materials that it had intended to include. My understanding is it had thought it included these materials. These are a number of bank records, bank statements, and some copies of checks and deposit slips. All of those materials were available at the time. I have them sitting here. It's a very short pile. I have them sitting here in front of me. And these bank statements demonstrate, I believe, clearly and in a fairly small number of pages, how the campaign bank balances, account balances, went from the $4,823.05 in September of 2018 to an amount sufficient to pay Strzok and Levan's legal bills in connection with post-election compliance work. That check was supplied. A copy of that check to Strzok was supplied in response to the enforcement notice, and then back down to the number that it is today. We have the bank statements. We have the checks. It was a mistake. The campaign manager who was preparing the response to the enforcement notice simply did not include it. I have that information. The reason why we did not subsequently, after receiving the enforcement notice and responding to the enforcement notice, submit to CFB staff these additional materials that the campaign had mistakenly not included is, I believe it was Ms. Persky, or it was members of the staff advised us that that is not pursuant to, I believe, Board Rule 702C2. We were not to submit anything further. We did have those materials. My understanding of that rule, I read it. I believe the CFB staff has the view that the board is not, should not perhaps consider these materials that were not timely submitted. My understanding of reading the rules that the board may, in its discretion, consider those materials, and I would request that the board do so. And I apologize again because I understand that that has imposed an additional time and would impose some additional time on both the staff and on the board to review materials that that staff would have in the ordinary course considered in the course of reaching a determination, and I apologize for that.
So it is a suggestion that, and I'd like it from both sides, that these materials were proffered before today, but the rule was cited that they wouldn't be considered. When were they proffered?
So I can find the date, but Ms. Persky, roughly a couple of weeks ago, I believe.
That's all.
So, well, and
in an email exchange, right?
So what happened was we received the campaign's response to the notice. We analyzed it. It didn't make any reference to these documents specifically. It just said, here's the $15,000 check that explains the reduction in the bank balance, but didn't reference the other financial activity that obviously would have needed to have happened to get from $48,000 to something over $15,000 to $3,000. Didn't state that those other bank statements were being included. All we had was the $15,000 check and the final bank statement from May 20. Presumably, but there was no reference to them in the narrative portion of the response, so we had no reason to think that anything was missing. When I wrote to Mr. Cooperman to summarize the staff's updated recommendations to the board, I said that the bank balance had not been reduced because the campaign had not provided those bank statements between October and May, and affirmatively said the campaign should not, because I didn't want that to be misconstrued as an invitation to provide them now, said the campaign should not submit any additional documentation at this time. It is our policy to not accept any documentation after the notice response is submitted. The campaign had been given a 30-day extension to respond to the notice. The notice very clearly stated that all the bank statements for that period need to be provided, along with supporting documentation of any financial activity occurring during that time. Whatever did happen in the bank account during those months was not reported to the Board of Elections, so we didn't have anything to even compare our final bank statement to, because the numbers did not make any sense, and because we did not have any reporting to use for comparison, where we might otherwise have tried to sort of figure out ourselves what happened. We did not have the ability to do that, and we didn't think it would be fair to accept documentation late going against our policy that would advantage a campaign that had the resources to retain counsel, where another campaign might not have thought to ask for that opportunity.
This is another example of sort of the catch-22, because the staff takes that position. People often bring stuff. The board then makes a decision as to what to consider it. and then we're left in a position where because it's as opposed to 2 weeks ago today, there's no chance to have reviewed it before today's meeting.
Right.
So it really leads, all of this, I don't know what the answer is, but it leads to an unfortunate circumstance.
Well,
because-
I mean, since we're dealing with a law firm that does occasionally appear before us or
Yes.
periodically appear before us, I mean, if you're going to disregard the direction you get from CFP staff, then you should do it more promptly than waiting for the day of the hearing.
So I will say that Mr. Cooperman subsequently mentioned what he's saying now about that the campaign forgot to include those documents in the notice. That I believe you said that about a week ago or so when you said you would be appearing at the meeting. So it was after I said you should not submit additional documentation. So it's not that the documentation was offered and rejected. It's that it was sort of preemptively rejected, and then we were informed of its
All right,
existence.
let me pose this question.
Okay.
Assuming we're at least prepared to look at the documentation and without necessarily deciding that we're accepting it and are going to rely on it, we're in a situation where we don't want to waste a lot of time today. So we have two options, it seems to me. One is to just put this off to another day, or the other is to agree to at least you'll submit what you have. And I don't know whether a short narrative is necessary or whether the documentation is just going to be obvious what's going on its face. The staff from the CFB would want to look at it, perhaps submit a written response. But my question really is, do we hold this in abeyance subject to some written communications and then go ahead and decide it at a later date, but without another hearing? Or do we just bring everybody back and just say, okay, it's a do-over and we'll bring you all back next month? We have not really dealt with this in my time on the board. Maybe our executive director would like to chime in as to what would be a preferred procedure under these circumstances, again, without having decided that we're going to rely on these documents at all.
I mean, I think that making everyone come back, I mean, I think probably, I have just a question first to ask. Did you prepare this response? It's very unclear from the response because it's just a sheet of paper, whether it was prepared by the campaign or whether it was prepared by your firm.
Yes. So we worked directly with the campaign manager in preparing the response, as well as I'll just use the word instructed the campaign manager as to the particular documentation that was required, which is, of course, all of the documentation, both what we submitted and what I have here today. And my understanding from the campaign, what I was advised by the campaign manager after receiving the enforcement notice and then the response to our response to the enforcement notice, that there were just missing documents. And that's unfortunate. It should have been included. We worked with the campaign to identify there aren't a whole lot of records that were required to have been submitted. It's really just I think 7 or 8 bank statements and some copies of supporting checks and deposit slips. Those should have been included. We worked with the campaign and they just didn't end up in the envelope that was submitted by the campaign manager. I believe the campaign manager submitted it directly to the CFB. And so we did work with them, and it didn't end up in the envelope.
I think Amy was about to say that it's kind of not worth bringing people back.
Yeah, I mean, I thought it was going to be I mean, I think that if the board, I mean, the rule is that, and Bethany will correct me, is that there needs to be I can't remember the standard for not having submitted documentation, that it was unavailable or I'm not remembering the rule.
It's good cause and that it was unavailable previously.
Yeah. So if the board, again, is in their discretion chooses to accept the documentation, I think that there probably would be nothing else for anybody to say to have a second appearance. I think that the staff would require some time to look at it and may have some additional questions, because the reason that this is important is that it's not a couple $100. It's a fairly large amount of money going up and a large amount of money going down. So the chance that there are contributions from sources or that are impermissible grow with the fact that we're talking about $15,000 at least in and out, and so so there is some need, and there's no disclosure of what those contributions are. That I think the period covers at least one Board of Elections disclosure statement where these contributions weren't reported. So it would require some work on the staff's part, and maybe some additional questions to the campaign. So, but I don't think that would be any benefit to having people come back. I think it could be done on documents if the board chooses to accept this.
And I'll just note that it is not uncommon for the board to vote on a repayment of a final bank balance without specifying an amount in the event that the campaign has additional expenditures related to the post-election audit subsequent to that time, and the campaign would then provide bank statements and supporting documentation. So that could be done today, and then our auditors could take the time, if the board chooses to accept that documentation, could take the time to review it and determine what the number should be.
You're not contesting the obligation to repay the bank balance.
Of course.
The question is how much.
Correct.
Okay.
And I would, if I may, I would just add that, of course, I, Strzok, and the committee are, of course, happy to accommodate whatever procedure is put in place. I put together, for the benefit of the CFB, assuming that the board would agree to this approach, what I think is a very simple half-page summary of the six, I believe it was six.
I was going to give you one page. So half page is
Okay,
even better.
and it's 6 total contribution checks in terms of the money going in, and then there's the one check, the $15,000 check coming out. The bank statements show right when they were submitted. We have copies of the deposit slips that show when they were submitted, when they were deposited, and we would be happy to accommodate any protocol that the board wishes.
Yeah, so as Ms. Persky points out, that we do routinely, because often, the bank statement that was available, the bank fees come out, or, that they have to make one final payment. So that does routinely, the board, the staff, the board votes to have a campaign pay the final bank balance, and the exact number may slightly change after.
Right. Well, we have to go into deliberations, but I'm pretty confident that that's how we're going to come out here. And direct you to submit what you have to Ms. Persky. If you all can sort this out and reach an agreement as to the number, then we don't really probably need to be directly involved in that. Again, if there's a dispute, then we can sort of put it on for another day or another hearing. Okay?
Thank
All
you.
right, so we're going to go into deliberations
Thank you.
now. Thank you very much. session, and we're going to vote on penalties and repayments, including one matter where the candidate did not appear and is not contesting. So we'll take these in order. The first, and these are all in the form of a proposal, which we'll vote on all together. So the first candidate was Margaret Chin for the office of City Council District 1. The uncontested violation, which the board finds, is exceeding the expenditure limit. The recommended penalty or proposed penalty is $3,235. Second candidate is Pierre Gooding for City Council District 9, and the board is proposing to find the following violations and with the following penalties. One, accepting a contribution from a corporation. The board finds a violation, but no penalty. Two, filing late disclosure statements. Board finds a violation and a penalty of $285. Three, failing to provide bank statements. Board finds a violation and proposes a penalty of $50. The fourth item, the board is modifying the alleged violation. The board will treat this as a failing to document expenditures with a proposed penalty of $5,000. And five, commingling campaign funds with personal or business funds or funds accepted for a different election with the proposed penalty of $237 for total penalties of $5,572. Finally, candidate Mark Traeger, City Council District 47. The board directs a repayment of public funds, an amount to be determined based on a documentation that is being submitted regrettably late, but which will be considered. And if the board staff and the candidate can reach an agreement on that amount, they'll notify us. If there are further issues or complications, please let us know and we'll put this back on the calendar. All right. So that is it for those issues. We also, we need to vote. I said that was a proposal and now we need to vote. Thank you. So I'll move. Is there a second? All those in favor? Aye. Opposed? Abstentions? Done. Okay, thank you. We also have an advisory opinion to consider. I'll ask our executive director to tee up this issue.
We received an advisory opinion request from Lawrence Laufer on behalf of the Stringer for New York campaign, asking about the application of the contribution limits based on a law that was passed, Local Law 128 of 2019, which amended the Campaign Finance Act to require candidates who select option A in the 2021 election to refund the excess portion of any contributions received prior to January 12th, 2019 that exceed the option A contribution limits. The advisory opinion that the staff has drafted says that yes, those contribution limits apply and that any contributions over those limits need to be refunded. Fundraising expenditures associated with previously raised contributions that are required to be refunded as a result of this legislative change will not be deducted from the 2021 expenditure limit. However, the cost of obtaining bank checks for the purpose of making those refunds will be deducted from the 2021 expenditure limit, provided that those refunds are made on or before January 15th, 2020.
Thank Thank you. I'll move the approval of that advisory opinion. Is there a second?
Second.
All those in favor?
Aye.
Opposed? Abstention? Motion carries. Finally, we have some final rules to approve. These are rules that have been previously published and comment has been received. And I'll ask our general counsel to briefly describe this issue.
Thank you, Chair Schaefer. On April 18, 2019, the board adopted for public comment several proposed amendments to the rules. The proposed amendments were published in the city record on April 19, 2019, and the board held a public hearing on them on June 13, 2019. No testimony was presented at the hearing, and the board received 2 public comments on the proposed rules. CFB staff is recommending that the board adopt these amendments to the rules regarding disclosure, contributions, expenditures, public funds payments, disclosure of independent expenditures, and various other aspects of the campaign finance program. These amendments include clarifications and updates to help support public understanding of and compliance with the board rules. The amendments also include minor plain language revisions and reorganization of text. If the board has any questions about the staff's recommendations.
Can I just say something?
Sure.
This is a massive reorganization of the rules, and I just want to take the opportunity to commend the staff who worked really hard on making these plain language and making the reorganizations, but in particular our Deputy General Counsel Bethany Persky, who has lived with making these changes for many years, and so she should be commended for the thoroughness and hard work that she did in preparing these new rules.
Thank you.
If the board is prepared to take action, the board staff now recommends that the board adopt these proposed additions to the board's rules as final.
All right, I move the adoption of these rules as final. Is there a second?
Second.
All those in favor? Aye. Opposed? Abstention? The motion carries. Thank you very much. At this point, I will make a motion that we go into executive session for some discussion, but no action, and adjourn thereafter. Is there a second?
Second.
All those in favor?
Aye.
Opposed? Abstentions? We are done for today. Thank you very much.